sentence for his crimes in a procedural hearing where the only possible punishment is life in prison without the possibility of parole.
Well, there's a lot at stake for Scott Peterson this week out in California. His bid for a new trial. Joining us now, Court TV legal correspondent Joylyn Macron has been monitoring what's going on, and today was another extension of this hearing that's been protracted because of some COVID issues, but they're back on the record.
Yeah, and you know, just a reminder for our viewers that this hearing is really about whether he should get a new trial based on those allegations of juror misconduct. And the major headline really out of today is that a key witness that the defense wanted to call refused to testify, and she's a documentary filmmaker, Shireen Anderson. She's executive producer of the A&E Network documentary, The Murder of Laci Peterson. The defense wanted her to testify about Rochelle Neese, this juror, also known as Strawberry Shortcake, juror number 7. And those allegations of misconduct, which we've been covering here on Court TV, well, the defense say justify a new trial. They all center around Neese. Defense attorneys say she referred to the unborn Connor Peterson as little man and was biased in convicting Scott Peterson of killing Connor and Laci. They wanted Anderson to testify about a 2017 interview that she did with Neese at Neese's home, where she spotted a photo containing a representation of little man. Well, so she says. A briefing filed just this week by Peterson's attorney cites Shireen Anderson's interview with the Stanislaus County District Attorney. And here's a portion of it. This is the transcript. Ms. Anderson described what she saw as she left Ms. Neese's home. And this is Ms. Anderson's own words, this portion. There was a wall of photographs of family members and kids. There was a baby, photograph of a baby, and a onesie, wearing a onesie. And I think, you know, an infant, maybe 9 months, 10 months, something like that. And on the onesie, it said, little man. Now, the briefing also argues that it is Ms. Anderson's burden to establish that she's a radio or television news reporter or other person connected with or employed by a radio or TV station. Even if shield law applies to Ms. Anderson, her claim of immunity should be denied. So essentially, she was asserting her right not to testify here, claiming that she had immunity or privilege in this case, but ultimately it didn't get to that. There was a stipulation. Her attorney essentially said what she would have said had she testified, and that was really what the defense was looking to, and it was regarding that interview that she conducted with Rochelle Neese back in 2017, and all of that concerning the photograph, that representation of little man.
Yeah, which, you know, it is an eyebrow raiser a little bit because of the fact that she referred to Connor Peterson, the unborn son of Laci and Scott, as little man after the conviction, saying that, you know, we got it for little man or something to that effect. What's the process now? This is a days-long hearing. It's, again, been uninterrupted. It's going to all be up to this judge, right?
Yeah. And actually, there's testimony. Last I checked, when I came down to the studio, there was testimony still going on. At that point, there was testimony at the time from an East Palo Alto police clerk who was involved in the case. And testimony is actually expected to continue into tomorrow. So certainly there could be some new developments, but the key witness that we were watching out for today was Shireen Anderson, and we know what happened with that now.
And this whole thing has started because the California Supreme Court did look at the appeal and said, yeah, there's something here we want answers to. So they've ordered this judge, you look into it, you make a ruling, and then this ruling will stand. At the end of the day, Peterson could get a new trial.
Absolutely, he could get a new trial. And, you know, you conducted that interview with a family member of Peterson's, and it sounds like they're doing everything they can to get him that new trial.
Yeah, and as convinced as so many people are of his guilt, his family has never ever wavered. They've supported him 100%. Joylyn Macron, thank you. Let's bring in our guest, talk about this in San Francisco, criminal defense attorney Joseph Tully, and let's welcome to our conversation from Dallas, Texas, former DOJ senior attorney and former federal prosecutor Tammy Allison. Good afternoon, Tammy. Thanks for your time. Does Scott Peterson have a chance here?
Well, thank you for having me, first of all. Yes, Scott Peterson has a chance. As we heard your conversation, you know, any of these procedural defects, California Code of Civil Procedure 6, and it clearly states that any type of misconduct by jury members is a ground for a new trial. So as guilty as we all think Scott Peterson is, I definitely think he's guilty AF. Trial.
Joseph, you're there in the Bay Area. We had Michael Cardoza on last hour, and he thinks that he deserves a new trial, but there's no way he's getting one because he's Scott Peterson. Your thoughts?
I agree. Maybe I'm being cynical, but based on what I see in court, judges are human beings, and they are very influenced by the political nature of their decisions sometimes. And especially in this case, they don't want to be the judge who's soft on crime, who let a murderer loose on a technicality. That's every judge's nightmare.
But Joseph, do you think he deserves one?
I think he deserves a chance to have one. I really would. I think it could go either way. I think that, just the little man comments that we just saw, I don't think that's enough. I think, maybe somebody refers to all, little babies, male little babies as little man. So it's a very common expression. I don't think that's enough for a new trial, but, that in combination with everything else, possibly.
Well, the fact that if she lied on the questionnaire, if he's not Scott Peterson and a juror did lie on a questionnaire multiple times, that could trigger a new trial, could it not?
Well, it could, but I mean, realistically, if he's not Scott Peterson, it's not in the papers, nobody knows about it, and judges, again, are very reluctant to grant defense attorneys motions. I write them all the time, and I make them as perfect as possible, and they don't get granted, so good luck with it.
Tammy, you've always been on the other side of things. Judges love you people. And to that point, isn't it an inherent uphill battle coming from a defendant who's been convicted of double murder, and his name's Scott Peterson, and of course, hello, the Bay Area knows this case so well. This judge will always be known as the judge that gave Peterson a new trial.
It's that right? Inherent bias in the policy and procedures.
Tammy's
and experience bias. What's going on here is
All right, Tammy, we're going to cut you off. We got some technical issues. We'll work those out in the commercial break. Joseph, lastly to you, the other decision made by the California Supreme Court was to take Peterson off of death row for a decision that Judge DeLucchi made. And that decision was that any juror that came in and said that they were against the death penalty, he removed them right away without any sort of inquiry to see if they could still follow the law, even though they religiously or what have you, they had feelings against the death penalty. That was a clear decision by the Supreme Court. They weren't. It was pretty clear that they were not divided, that he should not have been sentenced to death because of that in the penalty phase. Your thoughts on that decision?
I think that was the absolute right decision by the California Supreme Court. The law is that if somebody's facing the death penalty, a juror has to be able to say, I could impose it. So, there's always an argument of somebody facing the death penalty doesn't get a jury of their peers. You have to get people who only would impose the death penalty. So here's somebody saying, I'm against it. They were off, whereas the inquiry should have been, okay, even though you're against it, can you impose it in some circumstances? And if the answer was yes, they should have been allowed to stay on the jury.
Yep, and that was the decision by the High Court. All right, we're going to work on Tammy's signal there. Looks like it's come back. Take a break. Coming back, we're going to also replay an interview I did a few weeks ago with one of Scott Peterson's family members, Janie Peterson. She's convinced that her brother-in-law is deserving of a new trial. We'll talk about that next.
We know that Scott will someday have a new trial and have an opportunity to show the new evidence we have, show that he is innocent. There's a lot of things that went wrong in this case, and this jury misconduct issue is just the latest.
Stinks.
Welcome back to Court TV Live. Right now in San Mateo, California, there's an evidentiary hearing for Scott Peterson that's been going on for a few weeks. There's a little interruption because of COVID. The heart of this hearing is it's a fact-finding hearing that the judge has to determine whether or not Scott Peterson, after 18 years of imprisonment, after being found guilty of killing his wife and his unborn son Connor, does he deserve a new trial? And does he deserve a new trial because of the conduct of one of the jurors that sat in judgment of him 18 years ago, a woman by the name of Rochelle Nice? Today, they continue that hearing, and we've been updating it throughout the day. A few weeks ago, after the first day of this hearing, when that juror, Rochelle Nice, actually went in under oath and testified, I talked to Janie Peterson, that's a stepsister of Scott Peterson, after that first day. She was in court as well. Here is a portion of that interview. The first day is in the books. Rochelle Nice took the stand under oath and talked about her questionnaire and the answers to it. And a couple of things that did come out in this hearing, that she wrote that she was never a victim of a crime, or that a family member was not a victim of the crime. She checked no to that. And it came out that indeed she had asked for a restraining order while being pregnant because she accused a woman of stalking her and basically threatening her. And then also a potential domestic violence victim also in 2001. She brushed them off. You were in the courtroom. In your opinion, and I know you're biased, how did she come across?
I think she's testifying in a very frank manner. I think the biggest thing that came out Friday was we now have a third document that she has signed under penalty of perjury that had false information on it. When we went into court, we knew that her jury questionnaire contained false information, as you said. She indicated she'd never been the victim of a crime. She'd never testified in court, which she had. She'd never been a party to a lawsuit, and she was. So the jury questionnaire had false information. She also signed a declaration in conjunction with this case about 2 years ago. That contained false information, which led her to ask for immunity on Friday before she testified. And then while she was testifying about one of those restraining orders, she said that she really was not fearful for the life of her unborn child. She just filed it to be spiteful. So that's a third document that was signed under penalty of perjury with false information on it.
What do you say to someone who's like, oh, who cares? You know, there was 11 other people on that jury. It's not like she went in there and wrestled them up and convinced them. The facts are there. The jury, at the end of the day, after trial, Scott Peterson was convicted. What she did wasn't enough to warrant this to be overturned. Your response?
Well, as our appellate attorney Cliff Gardner says it very well, that our Constitution entitles you to a jury of 12 impartial jurors, not 11. So this is a really big deal. It's incredibly hard to overturn convictions because our justice system protects jurors. So they take juries, the courts take juries very seriously, and because of that, this is a very serious issue.
Do you believe that she was a force on this panel? I know that the judge is going to be hearing during this period of time, during this 5-day hearing, from some of those other jurors. Do you think that she was an actual force that did make a difference in that deliberation room?
Well, every single juror in a criminal case makes a difference because you need a unanimous verdict, especially in a capital case. So absolutely she was a force. Every one of those 12 jurors was a force and needed to be truthful on their questionnaire and needed to be impartial.
After the conviction, after it was all over, she did something extraordinary, and that was she wrote to Scott Peterson on several occasions, and he apparently wrote back. What do you know about those letters, those correspondence between the two, and to what extent will they be brought into this hearing and to prove what?
Well, what's at issue here? The first thing that's at issue is, and it's Scott's burden to prove that there was juror misconduct, and juror misconduct is simply having false information on your questionnaire. So proving that is not the big problem. The next step, the burden then shifts to the prosecution, and they have to prove that she was not biased. So that's when all these letters are going to come in. When we see that the questionnaire was filled out improperly, there is a presumption of bias. So then the prosecution is going to have to show that she was not biased. And that's where the letters are going to kind of be, maybe some different parts of the letters will come into play. Parts of maybe media interviews that she did, part of the book that she wrote will go to show her bias in the situation.
Following the guilty verdicts, there was a press conference held by a number of jurors, and she was one of them. And during that press conference, she referred to Connor as little man. And it then later was divulged that she had referred to her own child as little man during her own pregnancy. What is that going to be something that's brought up? To what extent, and what do you think that means?
Well, I think it means that she nicknamed the Scott and Lacey's unborn child, Connor, the same name. So she was asked that question on Friday, whether she had that nickname for her child, any of her children, and she said she did not recall. But as you said, you can see on the court website in the offer of proofs that there will be witnesses who testify that she very well might have nicknamed her own child Little Man prior to serving as a juror.
She said on Friday, I had no anger for Scott Peterson before this trial. I came in as a juror. And then, yes, I did have some anger after I heard all of the evidence. That, to me, is a reasonable response. Do you disagree with that? Do you think that she came in with an agenda? And if you do, why do you think that?
I don't have an opinion about that. I think that's what these hearings are here to establish. I think legally there's a problem with how she filled out her questionnaire. It's going to create a presumption of bias, and the prosecution's going to have a difficult time establishing that she was not biased. Because when you look at the body of information we have, whether it's her history before the trial, during the trial, or after the trial, there's not going to be a lot of evidence to present that shows her not being biased.
In the 18 years since his conviction, your brother-in-law, Scott Peterson, has maintained his innocence. His family, including yourself, has supported him over this period of time. To what degree do you have a sense of confidence, hope? How would you qualify what you're feeling, what he's feeling right now in terms of this probably last opportunity, potentially, for a new trial?
Well, we have a lot of hope, and part of that is because this is not our last opportunity. So we continue to have an ongoing investigation. We still have appeals that we can pursue in federal court. But this claim in state court is a very strong claim. And so we have hope and we have confidence in our attorneys and our legal team, which, just to correct you earlier, I'm not quite an attorney yet. I graduate in a couple months. But and we know that Scott will someday have a new trial and have an opportunity to show the new evidence we have, show that he is innocent. There's a lot of things that went wrong in this case, and this jury misconduct issue is just the latest. So we're glad we have this opportunity in court to potentially overturn his conviction and get him a new trial.
The Supreme Court of California had an issue with this, and that's why they sent it back down to this court and said, please investigate this, figure this out. The other decision that the Supreme Court made was that he should not have been on death row, and now he is no longer on death row. He's no longer facing the death penalty. To what degree does that bring you, him, the family, a sense of relief, that decision by the Supreme Court, and even this one?
The decision that overturned his death penalty was actually, we actually knew right away, right when he was sentenced to death, that the death sentence would never stand because of the error the judge made. It was a pretty established law, but it just took 18 years to do it. So we always knew he would never be executed because of that mistake. But I have to say, when the death sentence was actually overturned, there was a sense of relief. It was official. That the state wouldn't be sticking a needle in his arm.
To what degree, I know you're very involved To what degree is Scott Peterson involved in his own defense?
Very much so. I mean, he's he reads all the briefing. He does case research. He's very involved in participating in his defense.
What's his day-to-day like now? He's no longer at San Quentin.
Correct. He's currently at the county jail. The county jails are quite a bit different than prison, so they're very different day to day. And I haven't heard all the nuances of how his day goes, but it's a lot more difficult to communicate with him in county jail. He has a lot less. Well, actually, now he technically has email, which he didn't have before. So, but his, doesn't have the same amount of paper and pens, and it's just a little bit, it's different. But he will only be at this county jail, I think, within 10 days after the end of this hearing this week. He'll be moved back to prison while we wait for a ruling on this hearing.
And finally, if he does get a new trial, in your estimation, different outcome a second time around?
Absolutely. I am confident that Scott will never be convicted again.
Why not?
Just because of the body of evidence we have. The difference in the evidence we have from his first trial to this trial, you will never see a jury convict Scott Peterson of murder again.
That was Janie Peterson a few weeks ago after the first day of this hearing that was continued because of a COVID issue. It's finishing up this week. And then it'll be up to the judge, and that ruling won't likely come from the bench. It'll be issued later. Still with us, criminal defense attorney Joseph Tully and former federal prosecutor Tammy Allison. Hopefully Tammy's signal is back. The family is very confident that if he gets another shot, he's not going down. In any case, it's pretty hard, is it not, to prosecute someone 18 years later just because of witnesses, availability, et cetera. It's a different case no matter what the case, whether there's new evidence or not, Tammy. So if he does get a new trial, it's huge for him.
It is going to be so huge for him if he gets a new trial, because it's been 18 years since this conviction, and we have to consider if all of the evidence has been preserved, if the witnesses are still around, if there's going to be any exceptions to allow some of their testimony or their transcripts to be allowed into the new trial, if he is granted a new trial. But the likelihood of him getting granted a new trial under these circumstances, I'm not sure how strong of a case he has. Yes, he has a constitutional right to have a fair and an impartial jury, right? But here in this case, he also has to prove that there was prejudice, even if they do find that there was some type of misconduct from this jury member.
Yeah, it's one thing to say that she lied, Joseph, on her questionnaire. It's another to say that he gets a new trial. The bar's pretty high, is it not?
It is, and as we heard, the juror said, yes, I might have done this or that on the questionnaire. However, I came to this case open-minded, and I didn't harbor any feelings, negative or positive, towards Scott Peterson when I came into this case. Yes, at the end of the case, I was mad based on the evidence, but I came in here to be a fair and impartial juror. I think that's all the judge needs to deny the motion.
All right, we're going to see this hearing expected to wrap up at the end of the week, and then it will be up to the judge to see if Scott Peterson gets a new trial. Coming up, will Ethan Crumbley remain in an adult jail? And what about his education? We'll tell you what a judge ruled today in the case of the accused Oxford, Michigan shooter. That's next. Welcome back to Court TV Live. I'm Ted Rollins. Glad to have you with us this Thursday afternoon. New developments in the Oxford school shooting case. A judge ruled today that the alleged teen gunman, Ethan Crumbley, will remain housed in an adult jail. The 15-year-old is facing multiple counts of murder, terrorism, and other crimes for the shooting deaths of 4 students and injuring 7 others. Let's take a listen to some of the discussions today, and it turned to a discussion about whether or not he should be schooled, educated while in jail.
There are 2 options. She provided me a list that they are investigating of what they call either strict disciplinary academies or cyber schools. Unfortunately, he cannot proceed with that, which would be basically a regular school day, until the 2022-2023 school year, because as I know, I'm sure the court's aware, and everybody, that twice a year, every school district does, head count, and funding is based upon that head count. And we are past, obviously, the second semester head count. So for funding purposes, he will not be able to start a full cyber school year until next September, or this coming September. The other option would involve through the Michigan Department of Labor and Economic Opportunity, he would be able at 16, we would execute paperwork, and as his lawyer guardian ad litem, I can sign it as the court representative to implement either the high school equivalency program or a GED. And additionally, that would, once he has achieved either the high school equivalency diploma or the GED, he then would be able to continue in that program to be able to do some community college courses. On Tuesday evening, I received an extensive email from Marianne George she's a senior assistant at Corporation Counsel. And it involved what educational plans that are available that will either give him a high school equivalency diploma or a GED. And the two paths that exist, and I did meet with Mr. Crumley at the jail yesterday afternoon to discuss all of this, and it's an issue that we do have approximately a month to deal with, as the earliest implementation of anything cannot occur until he is 16, and he will be 16 at the end of April.
The court has been presented with a memorandum of law from the prosecutor's office. In summary, the prosecutor's office has been trying to work with defense counsel, as outlined by Ms. McKelvey, to try to get an educational program for the defendant to comply with the Michigan statutes that he is to continue with education, because he is indeed a minor. And it does appear to the court that that has been ongoing and continue to become a non-issue now, because it's in this court's opinion, at least, I believe that the parties are working together to resolve that issue. However, the court has not been presented with any additional information or new information that will cause this court to disturb its March 1st, 2022 opinion and order. Therefore, the court will continue the defendant's placement at the Oakland County Jail.
Let's bring back criminal defense attorney Joseph Tully and former federal prosecutor Tammy Allison. Tammy, is this about his education?
You know what? I have so much to say, Ted.
Well, go for it. We're here to listen.
He was black. Let's be very clear. Like, we're talking about his education. Listen, he is in adult jail right now, okay? So he has to deal with the adult consequences of his actions, okay? I went to law school in Michigan. Some of my friends still live there. I know firsthand that they were terrified. The schools were locked down. This 15-year-old murdered people, okay? This is not okay. And the fact that we're even entertaining his continuance of education prior to his trial is bizarre to me, because this is the same state where there was a 15-year-old girl who failed to do her online homework during the pandemic, and she was incarcerated. Wow. So, no, this is wild. Let him deal with the consequences of his actions. When he is convicted, he can then pursue his GED with an individual that is incarcerated with a conviction, just like every other person that is incarcerated does when they want to further their education.
Joseph Tully.
I disagree. Again, what we do to him, we have to do to all children. Just because a child gets accused of a crime doesn't mean that you shut down their opportunity or their avenue for education. If we're going to have children incarcerated, they need to be educated. And yes, he's being treated as an adult. However, he's still a child and he should be educated. Otherwise, all juvenile halls wouldn't have educational processes, and then the children would be released in worse than they came out. They'd be behind in their education, and that's something that we don't want.
Tammy?
Wow, child, it's the inherent blatant bias for me, because was Tamir Rice a child when he was shot and murdered? No. Wasn't he around the same age? We cannot conflate that these are people, this person here, Ethan, okay? He literally has murdered people, okay? Let's not refer to him as a child, okay? This is somebody who is a murderer, okay? Because if he looked like me, we would not be using the word child, okay? We would not even be entertaining his education. We would be going so hard to make sure he remains in adult prison and gets the highest amount of a sentence possible. So when we talk about the need for criminal justice reform, this is exactly what I'm talking about, okay? So if you're gonna call this little white boy a child, let's keep that same energy and make sure you're calling Black youth who are convicted or are alleged to be someone that did a crime a child as well. But I don't think that I need to pull in your receipts for you, but I think that we have one Google search will show you that when a Black minor is accused, they are not referred to as a child. Okay, this is a murderer. Let's be clear.
Well, he's not convicted yet. He's accused. And so we always need to have that acumen of he's accused. For everybody, yeah. I agree with you.
Sure. Okay, that's cute.
All right, we'll leave it at there. Obviously, and Allison, to Tammy, to Joseph, to Joseph, I've had Joseph on a lot. And I know that he would, I don't think it's a black and white thing at all for Joseph. He is all in on that side. He is the Mr. Public Defender through and through. So, but your point, a lot of people have the exact same feeling as you do. Really? Are we talking about his high school education, given the facts against him that he's facing? Let's take a break. Cool down, and then we'll talk about something else.
He said cool down.
We'll take a look ahead at another case that's garnered a ton of attention, and boy, is this a doozy. Sherry Papini, she alleged her abduction. Had a great story about how 2 Mexican women abducted her, and she just escaped. Well, according to prosecutors, it's all nonsense. She's back in court tomorrow. We'll talk about it next.
We shop, you save.
Welcome back. Let's turn our attention now to California and the case involving accused abduction hoaxster Sherry Papini. Papini, who is currently out on bond, is expected to show up for court tomorrow. This time, it's for her preliminary hearing. The 39-year-old is accused of faking her disappearance back in 2016, setting off a frantic 3-week search in Northern California. Papini was hiding out at her former boyfriend's house 600 miles away. She was arrested in March for lying to federal agents about being kidnapped and defrauding the state's Victim Compensation Board out of $30 grand. Court TV's Vinny Politan has a backgrounder on this case. Let's watch.
We are ecstatic to report that Sherry Papini has been located and has been reunited with her family on this day of Thanksgiving. At about 4:30 this morning, the Shasta County Sheriff's Office was notified that Sherry had been located. We've also learned that Sherry was released by her captor on a rural road near Interstate 5 in Yolo County. She was bound with restraints, but was able to summon help from a passing motorist who then notified law enforcement.
That was a 2016 press conference from the Shasta County Sheriff reporting to the public that 34-year-old missing woman Sherry Papini was safely back home with her family after a weeks-long search of California and surrounding states. Sherry was found with multiple injuries, bindings on her body and a brand mark on her right shoulder, and her long blonde hair had been cut. Sherry told authorities that she had been kidnapped at gunpoint by 2 Hispanic women and provided descriptions for an FBI sketch artist. After Sherry resurfaced, her husband Keith spoke to ABC News, holding back tears as he described being reunited with his wife after this entire ordeal.
Just ran past everybody, and I, throw open the curtain, and she was there in a bed, in her poor face. And I just hugged her, I just held her.
Since Sherry's story came out, many people questioned if such a wild tale could be true. And now, authorities have announced it was not. More than 5 years after Sherry's alleged kidnapping, she's been arrested on charges of lying to federal agents and defrauding the state. Authorities say that during the time Sherry was being held by her captors, she was really staying with a former boyfriend nearly 600 miles away from her home in Orange County, and injured herself to back up the story about the kidnapping. The mail fraud charges stem from Papini being reimbursed more than $30,000 by the California Victims' Compensation Board. The money was meant for therapy to treat PTSD from the alleged kidnapping, as well as the ambulance ride to the hospital after she escaped. The fraud charges carry a penalty of up to 20 years in prison, and the charge of lying to a federal agent has a maximum 5-year sentence.
Still with us, Joseph Tully, Tammy Allison. Tammy, you know better than most. You don't mess with the feds. They have her. Where's this thing going?
It can go very far to where she is incarcerated within the Federal Bureau of Prisons. This is a hot mess. And in the words of one of my idols, Gwen Eiffel, this missing white woman syndrome, which is a phrase that she coined, is something that is very relevant here with this case. She used racial stereotypes to accuse whoever of kidnapping her, when the whole time she was laid up with an ex-boyfriend, with her husband looking for her in shambles. Listen, we all stressed out, girl. We all want to run away sometimes, but you do not have to use racial stereotypes to go be with your ex-boyfriend when you're married to your husband. This is not okay. But it also highlights the need for the media to cover all missing persons, because we've seen this more than one time where these, people like this that don't look like me accuse people that look like me of kidnapping them, and then, it was all a hoax.
Joseph, you're there in San Francisco, in Northern California. I was there during this period of time as well. And it was all hands on deck for Sherry. And I can't imagine a jury having much love for someone who pulled this off. And to Tammy's point, accused 2 random Mexican ladies of torturing me, and with these bizarre sketch that was, this is diabolical on so many levels.
So I'll speak generally about this case because I do a lot of work in the Redding area, but it seems like the prosecution is going to have a very easy time proving its case here.
Yeah, and to that point, Tammy, do you think there'll be a plea deal after this prelim?
Ted, I like your word, diabolical. It was a diabolic mess if she does not take a plea deal. These are the feds. I'm former DOJ, former federal prosecutor, and it's like, listen, these charges here, they're not to be played with. Federal attorneys do not bring charges unless they have actual evidence. There's not going to be any games played if she chooses to go to trial. Federal courts are very serious. They are very much by the book. So it would be in her best interest to take a plea and go ahead and live your life with that ex-boyfriend. You ain't got to lie to kick it.
We'll see what happens. Again, tomorrow is the prelim scheduled. She's out on bail, and hopefully she shows up, and then we'll see what happens from there. I want to thank Joseph Tully and Tammy Allison for being with us today. Really appreciate both of you and your expertise, and your time is valuable, and we're very happy to have you along with us. That's going to do it for us for now, but don't go anywhere. Why? Well, Michael Ayala, he's coming up next. He's going to have the latest on the Peterson bid for a new trial. That and much more right here on Court TV, which, of course, is your front row seat to justice.